101 of hearing stream 10, and we're going into the wrap up of this hearing stream. So, Charles, can I hand over to you?
Yes.
To
Questions.
Thank you.
Yes, so I've just been capturing questions from each of the topics today, so I'll just run through them line by line and confirm that these are captured. Is that large enough, the text here for everybody to?
Even for me.
All right.
From the younger members.
Okay, so question 1. Provide a comparison table of the provisions between the operative and proposed district plan. And then a sub question to that, confirm how the operative plan managed matters such as bird scaring devices, frost protection devices, agricultural aviation, and reverse sensitivity from highways/rail corridors.
Yeah, it is really just the first part of that, but yeah, that's fine. If the table lists all of those activities that are in the proposed plan, and then has a column for operative and proposed, it could be simple as a tick box with just a third column with any comments for explanation. I think Katie's on to it.
Yeah.
Question 2. Provide a further description of how the proposed noise chapter applies in the proposed district plan. And providing this, a wiring diagram indicating how the objectives, policies, and rules, including the exemptions, applies would be useful to the panel. And a sub question to that, which the panel did ask a few questions on, was how does rule noise R3 and noise S3 apply, which is the state highway noise corridor rule?
Yes. There was some wording in the Kiwi Rail rule, post rule that
The habitable.
I have that captured
later.
elsewhere.
Yeah.
But I can move that up depending on how we.
Yeah, maybe just a cross reference even. Yeah.
Okay. Question 3. How do the current designations interact with the proposed district plan and the noise chapter with relation to managing reverse sensitivity? Any sub questions to those? Confirm the status of the current designations for rail and state highways in the Wairarapa, including how they apply spatially. B, what methods do the councils have to constrain or manage noise generating activities that are otherwise managed by designations? C, how would sensitive activities impact on designated activities that is not otherwise protected by the designation? And then D, what is the most efficient and effective method for managing those reverse sensitivity effects?
You gave a verbal answer to A that we relayed today, and the answer of B was, and I wanted to hear it from Kiwi Rail, was section 16.
Question about the increase in use of significant increase in percentage of use. Is that even, and they came back and said, oh, within designation we can do that. Is there some rules around, given that they've gone the opposite way over the last 20 years, and now all of a sudden they've changed course, and planning has obviously gone within the Wairarapa on the basis of their existing use. So now they're ramping everything up. Is there any rules around that sort of? I'm not quite sure how to phrase this.
The answer to that will come out in question 3B. What methods the council have to constrain or manage noise that are otherwise managed, actually authorised by the designation. There are no conditions on the designation, a bit of a free rein for the acquiring authority, Kiwi Rail. But section 16 of the Act, which is question C, does have a duty to avoid unreasonable noise. I think, is that the terminology?
Yes.
Yeah. Which And that applies to everyone operating under the Act.
Hmm.
And even if you authorise as it from a consent or a designation, still need, I mean, there's still that duty to deal with.
It's not so much to constrain or manage noise, it's the increasing noise that they're going to generate because of their
So
increasing.
if they're upgrading
Yeah.
their lines, how can we manage that, or what is authorised by the designation, which we will cover in point A. But given they have no conditions, it's down to the purpose of the designation and where it applies. Okay. 4, consider the additional relief sought by Mr. Michelle of the NZ Agricultural Aviation Authority to the introduction of the noise chapter, including the merits of the relief sought and whether those changes could be included as a consequential amendment. Question 5, clarify what activities from the suggested definition of temporary commercial helicopter activity as proposed by Ms. Wolf in New Zealand Helicopter Association would otherwise be permitted in the proposed district plan. And then a couple of sub-questions to that. In responding, comment on the current definition of helicopter landing area and whether it appropriately captures its intent. The panel specifically raised the reference to intended in the definition, which is subjective and does not provide certainty to plan users.
Was it intended landing or intended landing, wasn't it?
Intended or designed, I think it was.
Yeah.
Yeah,
Yeah, we also talked not a temporary commercial, but we talked about hunting, and so
but that is commercial. That's what they're classifying as commercial. That's what we're talking about.
I thought they were talking commercial as in civil construction.
That is a separate matter. I've also captured that.
Okay.
Okay.
One other thing in helicopters that we probably haven't, the sound, the decibel rating of, they named a Hughes 500 as the go-to. Does that cover all decibel ratings of the helicopters operated in the Wairarapa, or is it?
No, it's just specific for Chester Road, from what I could see.
Yeah.
Okay, yeah, well, he's got a bigger helicopter too, so I don't know.
It's well,
It was
That would be.
a different standard
yeah.
that it referred to that.
Okay, all right, that was later on.
But Mark, did you capture that later?
Yep.
I don't know if it's captured in there, but there is that change at
Models to types.
the type. Yeah.
We need to capture.
But it's only specific still to Chester.
Yeah.
It is.
The Chester Road, yeah, it's the Chester Road one. Not this is for all.
Yeah.
Yeah, we
Yeah,
can get that in. Have you got it in your?
I took it out. So just for clarity, where there was matters that that we felt could be clarified by the officer that didn't need to be publicly displayed, we've taken those out and separated those. So that was one of those.
Okay.
Okay, thank you.
And then B of question 5, also consider the exemption in clause D of the table before the rules and consider whether it provides enough certainty to plan users. And that clause D
Is that the agricultural one?
was in relation to that, yes.
Yeah.
Yeah.
Have you captured L? L.
L,
That is the
Oh, that's for
Yeah.
differently, I think.
question 6, clarify any previous engagement with Kiwi Rail prior to the notification of the proposed district plan. And clarify in this, provide dates and the form of engagement undertaken.
Okay.
Question 7, clarify noise standard 3. Clarify for noise standard 3 whether there needs to be specific requirement or advice note to include a report to confirm compliance with state highway compliance standards.
Yes. For example, so standard 3.
Yes.
For example, standard 4 does use the term design certificate. Then their very next standard. And I think the Kiwi Rail model rule also uses the idea, that concept too of certification. probably implied in S3, but it could be just clearer.
Question 8. What threshold would change Mr. Ardern's recommendation for approximate?
Spelling.
Oh, sorry.
I pronounce
ARDEN, Arden,
Harding.
So what was that? Sorry.
RDEN.
Yeah. I get it all the time these days.
Yes.
I've had an Arden.
Ah, right. Sorry.
When you're on TV, moving houses.
Mr. Ardern's recommendation for the performance standard to be 100 metres indicate the level of evidence, including noise measurements and frequency of trains.
This was the issue that I put to Dr. Childs about and to the council, that there's two components. There's the noise levels and exposure, but also how often they occur.
And then a sub.
Is that where you'll put the information about when was the last train on the northern part of the line, and whether the lack of any trains since I was a boy weakened there. I probably was on the last train that actually went north when weakened their argument,
The
for
dinosaurs
their noise
have
argument.
gone
Well, that's probably for us.
Yeah,
I know, but
that's
is that-
not in, yeah.
Well, we still need to know, and just to assess their validity of their argument. So I could write anything, but evidence, because if that's, then how much else is false?
I think that will also be covered by, I have a separate question in response to the submitters for Katie to reconfirm her position on the risks of acting or not acting, which that would factor in. So clause A, should the standard be specific to each district? And then just noting that the panel clarified that freight trains generally come from Wainawa going south. Question 9, how valid are the cost figures provided for landowners in the section 32 evaluation in the Taylor planning report provided in the original submission and the evidence of Ms. Hebbleweight?
Yes, that will probably require some evidence from the building consent officers at the three councils. And I don't want them to go to a big effort on this, but just a typical, there's two things. There's a acoustic insulation is the key thing, and mechanical ventilation. But it'd be interesting to see what they can provide on acoustic insulation, because Mr. Arden might be able to help there. I've always been told that modern building code requirements have a high degree of acoustic insulation for the new dwellings. Such that you may not need to do much more than over and above what the code stipulates to achieve insulation. It's the real cost will be in the mechanical ventilation to where you're relying on. Otherwise, we would have been relying on keeping windows shut.
Yeah, and that probably mechanical ventilation should read to outside atmosphere.
Yes, just so long as is that what the rule says? Doesn't, does it?
No, it doesn't, but
That provides at least one air change per hour, but no less than 7.5 litres per second per occupant. Do you have any knowledge of that? What that means?
So I think the 7.5 litres is building code minimum,
Okay.
unless that's changed.
is that just circulation within the roof cavity?
Yeah, so I think this,
No.
I think the 7.5 litres might need to be fresh air, but the rest can be made up of, because you don't take all the air out and put it in.
Right.
You take some of the air out and add a bit back in. So I think you can circulate it.
As long as it
Recirculated.
does that.
Yeah.
But there are three requirements and they're all conjunctive. First one I read. Second is it provides cooling and heating between a temperature range. And the third one is HVAC system installed in compliance with AB. Oh, there you go.
I thought it was interesting when they were also stipulating how loud the machine could be.
Yeah. That's very, very detailed and prescriptive.
Just remind me, I think there'll be a question about what consents the barrier would need. The under B.
Oh, do you want a question on?
Yeah.
Okay.
We'll come up to that, but just get off there.
So I've just captured an A there, for the council's building consent team to provide that response.
Yeah.
Question 10, provide a graphic of the rail corridor and state highway to indicate the overlap with corridors if both reverse sensitivity standards were adopted. In responding to this question, describe to what extent the state highway overlay, if adopted alone, would provide for any acoustic mitigation from the railway.
The panel assisted me with their local knowledge at lunchtime. Suggested it's probably only around Featherston where that overlap will probably occur, and it's where the highway goes across the railway. So there'd probably be a square.
Right.
You may be able to disprove that or confirm that. I don't spend a lot of time on the graphic necessarily. It's just to get it. It's about a flavour.
I guess to clarify on that one, the overlay, should that be based on the current designation or the rail and highway themselves?
Designation. Oh, how does the highway one work? What's the
As in the state
Yeah,
highway noise
yeah.
has been modelled.
oh, it has been modelled?
Based on
Yeah.
noise levels.
Yeah.
Yeah, so it's actually a bespoke line. Yes. So yeah, it's a intersection of the bespoke modelling line and the
From
step back from the boundary of the designation. I take your point that you made earlier that the designation is only rail land. It doesn't involve any other. The Kiwi Rail designation is only for over Kiwi Rail land. Yeah.
Question 11. Could the terminology in rule noise R13 be simplified by referring to habitable rooms within a noise sensitive activity as suggested by Kiwi Rail? Question 12. Clarify how quarrying activities are managed in the rural chapter of the proposed district plan and any associated reverse sensitivity effects. In responding to this question, Ms. Hoser may seek further advice from the reporting officer for the rural topic, which is myself. Question 13. So it's an open-ended question here, but respond to matters raised by submitters during the hearing.
Yes.
And I've just gone through each of those submitters and the key points that the panel raised. To consider the changes sought by Ms. Wharf for Horticulture New Zealand. Point 1, noise policy 1 and the suggestion of replacing the reference to receiving environment to zone. Point 2, the deletion of clause 2D from standard noise S2, which limits the number of bird scaring devices. Advice should be provided by Mr. Ardern. I'll change that again. Ardern on the appropriateness of the deletion and rationale for including a limit on the number of devices in addition to 2A, which sets the noise limit. Point 3, performance standard to require noise insulation for sensitive activities within 300 metres of a frost fan. Ms. Wharf suggested that there is recent case law to support this. Those examples will be provided to the panel and reporting officer. Point 4, whether the section 32 AA evaluation provides sufficient evidence to support the inclusion of a seasonal worker accommodation, inclusion of seasonal worker accommodation in the definition of sensitive activity, in particular if the costs for establishing seasonal worker accommodation and the additional consenting requirements have been appropriately considered.
Actually, the reverse of that, whether the 32A provides evidence to exclude.
Exclude, not include.
Yeah.
Support the exclusion of seasonal worker
Delete, include, yeah.
as it relates to matters other than state highway. I mean, obviously NZTA have scope to include seasonal workers in terms of the noise the highway. Outside of that, Miss Wolf was saying that there's an unintended consequence. Her client did not lodge a submission. They did lodge a. Yes.
Let me just quickly go back to the bird scaring part of it. Are we going to look at the time limits with it? It's half an hour.
Half an hour.
Thank you, if you come and start my question.
Yes.
Just mainly around my ones I wrote down about the evenings a little bit.
Mm.
Whether it's relevant on.
Was that Port?
It was Horticulture New Zealand.
Because they're requesting half an hour before sunrise and half an hour before sunset, and then
Half an hour after.
after sunset, sorry. And evidence was provided by a orchard who now don't
JR.
use them,
J2.
JR. That it's actually an hour to an hour and a half where there is still bird activity, but their submission is still requesting half an hour either side.
Yeah, so we guess in terms of what that needs to be added under
So
But under the right of reply,
yes.
As
I can't remember
opposed-
what
as
the rule
opposed
is.
to-
Can you-
I think it is,
Is it standard?
it's the standard, and I think it's part A of that standard.
Okay. Your answer might be more nuanced in that you may confirm your original position. You might say, yes, I accept the half an hour either side, or you might say, I accept it in the evening, but not the morning.
There's a thing called a silver twilight time. It's here. Silver twilight time called. It's a good way of.
But all of these matters will be with discussion with Ms. Wolf.
Yeah, I think you've got
Yeah.
further down.
The reason we've suggested that is the panel have some appetite for those suggestions. But we don't want to make a decision. Obviously, now we want to have this. We want to see those further questions answered, but wanted to see whether, based on now having had the benefit of hearing from Ms. Wolf, whether Katie, you think there's room for some movement.
okay, I'll clarify this question with Katie after.
That's why it's lead option 3.
that was Charlotte Wright's
Yeah.
evidence.
Okay.
It's just 2. It's not 2A, it's just 2 is the sunrise and sunset.
Was 2 of noise,
Yeah.
yes.
Yeah.
So if we move to below point now 5, there was just that clarification on the carve out that was suggested during the questioning of Ms. Wolf. Further discussions on that may be useful in understanding how that may work.
Yes, in fact, but those discussions and drafting would apply to not just that matter, but all of those preceding matters.
All of those matters, okay.
Sorry if that wasn't clear. I think Ms. Wolf understood that.
So just to clarify on that, you're not directing conferencing, it's informal discussions. we have got a separate matter for conferencing for the Helicopter Association, but
It's okay. It was more informal, I think. Yeah. But if there are agreements, it would be good.
I think
Yeah,
it was
right.
it suggested informal. If there's agreements, then
Okay.
present it as a JWS. But you'd say,
It could be as simple as maybe just covering it off in her 40, her right of reply saying that she's reached the following agreements. If there's disagreements, we'd probably just need to know what was the, because what the areas they were related to. Okay. That numbering still work, Charles?
yeah, so this is all part of question 13, which responds to submitters.
Now into B.
So B, consider the matters associated with temporary helicopter landing as discussed by New Zealand Helicopter Association, including the definition of helicopter landing area, which I think we've already covered previously. And then 2, is the helicopter landing associated with civil construction? How is the helicopter landing associated with civil construction managed? Should it be exempt or otherwise permitted? And then I have a separate point where we ended up pulling that out as conferencing, which shall we jump to now?
Yes, we could, because it wasn't just the definition of landing area, was the rule box.
Mhm.
It was rule 1, rule 8, and the definition.
Yeah, it's a wider issue about how the helicopters fit into the plan.
Okay, so question
They hover.
Question 14 is how that's been captured. So maybe if we just go through that and we can edit as required. So the panel directs expert conference thing between the reporting officer and the planning expert for the New Zealand Helicopter Association to consider the status of temporary helicopter landing for the purpose of civil construction in the noise chapter. The panel directs that experts consider and provide a joint witness statement that responds to the following.
that was also not just civil construction, but it was things like the telcos, if they need to fly in a technician,
Commercial.
surveying as well.
Fault finding.
Yeah.
Yeah,
Commercial approach.
commercial work,
Construction versus survey work.
yeah.
So I think that's why we talked, it's wider than just, it's more about, we only talked about things that we think about, but there's a whole lot of other things that helicopters do that we didn't think about. So you've got to go in with mind and say, what are all the activities that actually happen? How have we captured all the different activities that we use helicopters?
Okay. Would I guess, Katie, would you and the planning expert be confident you could capture all of those, or?
I think they mentioned a number of activities.
And Ms. Wharf was writing it all down while
Yeah.
It's generally things that aren't already captured already, like their conservation activity.
Yeah.
That's obviously now a solution there now, I think.
Outside of their ag work, basically.
RFD captured a lot, but there's other
yeah.
non-agricultural stuff and non-conservation stuff that they do.
Which was really useful because I think for myself, when I was reading commercial operations, I was thinking passenger stuff as opposed to, taking technicians in to check a line or fault finding on lines. So that it was actually a really, really useful hearing the submitters.
We go back to the preceding question before 14.
The question before 14.
13?
Well, this way.
You say it a lot.
Been a long day.
That reference to the definition of helicopter landing area. Am I conflating? Is 13 and 14 dealing with the same? Is 13B dealing with something
That would be,
is that covered by 14 also?
Well,
Well, it says referred to.
Okay.
so I get, as I was drafting it, I was starting with 13, but
Yeah,
the directions for the conferencing came, I split that out.
because
I guess the conferencing answer.
could point B, that's already covered in the conferencing, so do we need it at question 13? I think, is that what you
well, you
mean?
could leave it there and just say refer to question 14.
Yeah.
I'd rather
Captured it.
capture it here.
In both places.
Yes.
Yeah.
So just after question 14, put in brackets, you've done that. So.
Yeah.
Sorry. So before we go back though, question 13A, B1, definition of helicopter landing. It's not just the definition, remember?
So the rule box.
Yeah, the rule box, which is particularly
D and
D and L,
yeah, and then
and 3.8, not 3.8, rule
rule 8.
8 and rule 1.
Yeah.
Yep.
That was R1,
And rule 1
Yeah.
and R8.
R8.
And was there a standard? Three? Two?
2 on construction noise.
Yeah,
Yeah.
that's it.
Okay.
Yep, okay, now go back to the end of 14.
So are we happy with the chapeau of the direction? So moving into point A, what status the activity would have under the proposed district plan, just in brackets as recommended by Ms. Hoser. B, any recommended changes to the provisions of the noise chapter to provide for the associated, I'll just put activities, as it might be more than one.
Yeah.
And then any section 32 AA evaluation to support the recommended changes.
The thing that's missing is on the Kiwi Rail one about what land use consents would the barrier need. Now it will be, it depends, I'm sure it is obviously, but would it be subject to height and setbacks, etc. And if those weren't met, I mean, a 3.8 metre high barrier is probably about 20 metres long for a standard section, with probably not going to be exempt from land use control. And I put that question to Ms. Heppleway. She thought I was talking about building act, but it probably needs a building act consent too.
Did you want that clarified as well?
With the building consent people.
And then with that, bearing in mind the setback rules that we had previously on buildings close to the boundary line, that would also possibly
Yeah, that's what Councillor Plummer was
Yeah,
referring to.
be part of that too.
Hearing that.
for a noise barrier.
That was a building setback from the
From the
corridor,
corridor, yeah.
going stream 2, I think.
So I've just added this one in, but we'll start at the top of subclause C and Roman numeral I. Will there be a gap in how potential reverse sensitivity effects, and then in brackets, including managing the human health effects on those receivers, are managed should no noise control standards be included in the PDP?
Yes, there's a allied question to that came from Seppelwaite's policy analysis, and with the plan, I think it's a number 2, Roman numeral 2. If you can add a Roman numeral 2.
Yeah.
Well, it's the same question. Will the plan fail to give effect to policy 8? The RPS. There be no noise control standard in the PDP. Ms. Rapley or Ms. Headway were right that the risk of acting is only when the information source is uncertain. But the panel was relying on Katie's indication that there was some uncertainty as to costs, etc., and train numbers, etc., which wasn't satisfied on at the end. So I think we do trigger that question about the risk of acting or not acting.
So then this point we added before, what authorisations would be required under the RMA and Building Act for
So that's the question.
noise
I
mitigations?
repeated that, sorry.
I put that in as you were
Okay.
talking to.
Gosh, it's been a long day.
And then finally, the panel requests that Kiwi Rail provides, one was the clarification of noise standard S4 subclause 2A3 and the reference to HVAC system. So I think that was Councillor Teller's question on that. And then two, the spatial mapping extent of the proposed rail vibration alert area overlay and the rail corridor noise control boundary overlay.
Is this audit system that Ms. Heppelway referred to? Where she nuanced the boundary based?
That's right, yes.
Do we need to get do we need to have an understanding of what the effect of a vibration alert overlay would have? The benefit versus risk of having that? Because at the moment they've just said, yes, we should be doing this, but what is the effect of having that?
Is there a specific question though that I think I know where you're going. Is there a specific question you could frame for Charles to record about this benefit?
You know where I'm heading with it.
Yeah. I think I know. I could suggest the wording is if the rail vibration alert area is adopted, what are the council's obligations under the Local Government Act to include that information on a limb or PIM?
Yeah.
Voting.
Is that what you're getting?
Yeah, well, we've seen the effect of
Yeah.
water and liquefaction already. So do we add another potential cost?
Is that's not a question for that.
Not a question for Kiwi Rail, no.
That would be for
Yeah. And for Roman numeral 6, how is that going to be conveyed?
that was going to be a question for the panel. So I guess one would be to set a time frame for how long you would like that provided, but
Does that require a minute though?
it will require a procedural minute. So
We can talk about that. I think the idea was 2 weeks after the close of the hearing, but I'm also conscious that in this instance, the week after next.
Next week is Easter.
Yeah, next
And then
week is Easter.
one week is Anzac Day.
Yeah, and a large number of the country are going to be absent between the Easter and Anzac Day. So we might just factor that in terms of the 3 weeks. We might add in another week.
okay.
For the right of reply, and a week back from that for the response.
15 working days.
Kiwi Rail. Yeah. It's really time frames for everyone, isn't it?
Yeah.
Really, really puts the onus on and Ms. Wolf getting together sooner rather than later, I think. You probably want to have that done and dusted by the end of next week, which is the Thursday, the 17th, I think, or 18th. Otherwise you won't get round to it till the 26th, 28th.
Yeah, it's Thursday the 17th.
Okay, if that's all for noise, we can move on to activities on the surface of water, which is a very brief one, as I had no specific questions arising. For lights, question 1, reconsider the inclusion of mobile machinery and the exemption of light standard 1, including any further clarification that may be provided by Horticulture New Zealand at the hearing. Consider any other requirements, consider any requirements for vehicles. I think that might be, I might have done an incomplete sentence there, but I think that may have been in relation to outside of the RMA processes.
Probably get rid of that.
Okay,
If in doubt, leave it out.
I think that mobile machinery was whether Becca was going to buff out the difference between vehicles and mobile machinery.
Things like combine harvest.
Yeah.
All right.
Yeah.
That's
That's what that was.
Orchard sprayers.
and then question 2,
That's fine.
that's fine there. So moving into signs, there was no questions arising. And then lastly, the temporary activities. Clarify rule temp R3. If temp R3 captures the likely goods or materials that Von Hogan is likely to require storage of. And then point A to that, consider whether the wording of goods and materials is necessary given outdoor storage is a defined term.
One final question for the Kiwi Rail one.
Yes.
And just to give a it relates to the cost and benefits. Whether you are in a position to provide any update costs and benefits associated with those overlay and rules. On planning perspective.
So both the noise and the vibrational just
Just the noise, because vibration doesn't have any rules.
Do you want that specified as a?
Yeah, I do.
So after considering
That you were 42 was a little bit light on that, but I can understand why. But the two attachments to the evidence, the Taylor planning report and the insight economics report, both sections on cost. Those reports focus largely on the costs to Kiwi Rail in terms of maintaining their the network. There's some sections there that focused on cost to individuals, but they were very short sections. I think I gave a reference earlier. That was in the Taylor report. That was page 15. Last paragraph that goes on to that on page 16. And there was, I think it was the Taylor report. Yeah, section 32 report. And there was something in the insight report too. I find my hand on it, but yeah, I'm sure you'll find it. So, inside economics. You just bear with me, I'll give you the page reference. It was paid a numbered page, section 10.2. There's a table there that talks about cost. And the figure 3% is used there. That's it.
Okay. Well, that was all of the questions. So if there was, unless there was anything else that the panel felt wasn't captured, I think that should be it.
Oh,
Great.
okay. Thank you. Thank you
Thank
for a
you.
really long day. Just to close our hearing stream 10, if we do our karakia whakamutanga. Kia whakaria tapu, wātia aitia, kia turuki whakataha ai, kia turuki whakatahi ai. Haumie, hui, taiki. Thank you all very much.